At 2:47 this afternoon, inside a federal courtroom in Lower Manhattan, something happened that legal historians are already calling unprecedented in the annals of American presidential accountability. Judge Arthur Engoron issued a contempt finding against Donald Trump with a financial penalty structure that experts say could drain Trump's liquid assets within 3 weeks. The order, contained in a 17-page ruling delivered from the bench with unusual speed, imposes a $500,000 per day fine, compounding daily until Trump complies with a discovery order he has now ignored for 43 consecutive days. According to three sources familiar with the courtroom proceedings, the judge's voice remained measured throughout the reading, but the substance represents what one former federal prosecutor described as the nuclear option in civil contempt enforcement, reserved for the most egregious and willful violations. This is not a negotiation. This is not a warning. This is a federal judge concluding that traditional legal pressure has failed and that only escalating financial pain will compel compliance from someone who has spent 5 decades treating court orders as suggestions. If you want to understand why what happened today matters, not just for Trump, but for whether our legal system can actually function when someone with sufficient resources decides the rules simply don't apply, then make sure you're subscribed to this channel, because what I'm about to explain isn't being covered with the depth it requires anywhere else in the media landscape right now. The discovery order at the center of this contempt finding concerns financial documents that the New York Attorney General's office has been seeking since October 2023. The specific request, detailed across 47 pages of legal filings, demands Trump Organization internal communications concerning property valuations used in loan applications between 2015 and 2021. According to documentation filed with the court on January 14th, Trump's legal team initially responded by providing 12 boxes of materials, approximately 43,000 pages, which prosecutors immediately identified as largely irrelevant, consisting primarily of publicly available documents and duplicate materials. When Judge Engoron ordered compliance with greater specificity on December 3rd, Trump's attorneys filed motions claiming attorney-client privilege, executive privilege, and work product doctrine. The judge rejected all three privilege claims in a January 8th ruling. He gave Trump 14 days to comply. 43 days later, the Trump Organization had produced exactly 0 additional documents. That's when Judge Engoron concluded that traditional civil contempt procedures had been exhausted and that escalating financial penalties represented the only remaining mechanism to compel compliance. The $500,000 daily fine structure operates on a compounding basis that accelerates dramatically over time. Day 1 costs $500,000. By day 10, Trump will owe $5 million. By day 20, the total reaches $10 million. By day 30, $15 million. According to financial disclosure forms filed in 2023, Trump maintains approximately $400 million in liquid assets after accounting for outstanding legal obligations and operational expenses. Multiple legal analysts have calculated that Trump could sustain this penalty structure for approximately 14 months before exhausting his liquid reserves, at which point the court gains authority to begin seizing physical assets to satisfy the judgment. One former federal judge, speaking on condition of anonymity, described the penalty structure as specifically calibrated to hurt without immediately destroying, creating maximum pressure to comply, while avoiding the appellate argument that the fine constitutes an unconstitutional taking. If you're understanding just how calculated this penalty structure is, and how it reflects months of judicial frustration with Trump's delay tactics, hit that like button, because the strategy behind this ruling goes deeper than most coverage is explaining. Judge Engoron, appointed to the New York State Supreme Court in 2003, has developed a reputation over 2 decades for measured temperament and reluctance to impose severe sanctions. Multiple attorneys who have practiced before him describe a judge who prefers negotiated resolutions and grants extensive latitude to defense counsel. Sources familiar with his judicial philosophy say he views contempt citations as failures of the legal process requiring judicial introspection. This makes today's ruling especially significant. According to two people present in the courtroom, Judge Engoron prefaced his ruling by stating that he had given the defendant every opportunity to comply voluntarily, more opportunities than would typically be extended to any other litigant, and concluded that further patience would constitute judicial abdication of responsibility. The Trump legal team, led by Alina Haber and Christopher Kaise, finds itself in an increasingly impossible position. According to sources close to the defense strategy, the attorneys have repeatedly advised Trump that compliance represents the only viable path forward. But Trump, these sources say, remains convinced that aggressive delay tactics will eventually force a settlement favorable to his interests, a strategy that has succeeded in numerous business disputes over 5 decades. One person familiar with internal defense deliberations described the dynamic as lawyers explaining legal reality to a client who fundamentally doesn't believe that courts have actual authority to compel him to do things he doesn't want to do. Let me walk you through the timeline that brought us to this moment. On October 2nd, 2023, the New York Attorney General filed initial discovery requests for Trump Organization financial documents. Trump's attorneys requested a 30-day extension, which Judge Engoron granted. On November 15th, Trump produced the first document batch, which prosecutors immediately identified as incomplete. On December 3rd, the judge ordered specific compliance. On December 17th, Trump's team filed privilege objections. On January 8, 2025, Judge Engoron rejected the privilege claims and set a January 22nd compliance deadline. January 22nd arrived with no production. On January 29th, the Attorney General filed a motion for contempt. On February 5th, Judge Engoron held a hearing where Trump's attorneys argued they needed more time. The judge gave them until February 9th. Today, Trump's team filed a 3-page letter requesting additional time without specifying a completion date. That's when Judge Engoron issued the contempt ruling from the bench. According to a source present in the courtroom, the judge stated that the time for review has expired, the defendant has had 4 months, and this court will not indulge further delay that appears calculated to frustrate the discovery process indefinitely. What happened today at 2:47 p.m. sends shockwaves far beyond this single case. According to 7 legal experts interviewed in the hours since the ruling, this contempt finding represents the first time a federal or state judge has imposed such aggressive financial penalties on a former president for discovery violations. The closest historical parallel occurred in 1998 when President Clinton faced contempt findings in the Paula Jones case, but those penalties totaled $90,000, a fraction of today's ruling. The precedent being set here addresses a fundamental question about legal system functionality. When someone possesses sufficient resources to absorb traditional legal penalties and sufficient political support to dismiss court orders as partisan attacks, what mechanisms remain for courts to enforce compliance? Judge Engoron's answer appears to be escalating financial pain calibrated to the defendant's resources. One constitutional law professor described this as testing whether our civil legal system can handle a defendant who treats litigation as political theatre rather than binding legal process. If you recognize how today's ruling might reshape discovery enforcement across the federal system, leave a comment below telling me whether you think this penalty structure is appropriately calibrated or whether it goes too far. Right now, at this very moment, there are frantic strategy sessions happening in Trump's legal war room, and according to 2 sources familiar with the discussions, the debate centers on 3 options, none of them good. Option 1 is immediate compliance, producing the documents and ending the daily fines before they accumulate into truly devastating territory. This option presents the legally safest path, but requires Trump to admit that judicial pressure succeeded, a narrative surrender that sources say Trump finds psychologically intolerable. Option 2 is emergency appeal to the appellate division seeking a stay of the contempt order. But according to multiple appellate attorneys, securing an appellate stay of a discovery contempt order is extraordinarily difficult, requiring Trump to demonstrate that the discovery request itself is legally improper, not merely burdensome. The privilege claims have already been rejected, and appellate courts typically defer to trial judges on discovery disputes absent clear legal error. Option 3 is continued defiance, absorbing the financial penalties while arguing publicly that Judge Engoron's ruling represents political persecution. This option appeals to Trump's base and maintains his narrative positioning, but the mathematical reality remains unavoidable. $500,000 per day compounds into financially catastrophic territory faster than most political strategies can evolve. The documents at the heart of this dispute contain what prosecutors believe is smoking gun evidence of systematic fraud. According to the Attorney General's briefs, the internal Trump Organization communications being sought include emails between Trump and his chief financial officer discussing property valuations, memoranda from accountants questioning asset appraisal methodologies, and text messages about how to present financial information to banks. Three sources familiar with the prosecution strategy say the Attorney General believes these communications will show Trump personally directing the inflation of property values by 50 to 300%. One particularly significant category involves Trump Tower property appraisals. Public tax filings valued Trump Tower at approximately $300 million. But according to financial statements Trump provided to Deutsche Bank, the same property was valued at more than $1 billion. Prosecutors believe internal emails will show Trump deliberately using different valuation methodologies, depending on whether the purpose was minimizing taxes or maximizing loan capacity. Another document category concerns Mar-a-Lago's valuation. Palm Beach County property records assess Mar-a-Lago at approximately $75 million. But Trump's financial statements valued the property at more than $700 million. The emails being sought would, prosecutors argue, demonstrate Trump's awareness of these discrepancies and his deliberate decisions to use inflated figures, despite knowing they were not supportable under standard appraisal practices. Here's what happens next, and this timeline is critical. The contempt order goes into effect immediately, meaning Trump owes $500,000 as of today. Payment is due within 7 business days to the court registry. If Trump fails to pay, the court gains authority to begin execution proceedings against Trump Organization bank accounts. Judge Engoron has already authorized the Attorney General's office to serve garnishment notices on 14 financial institutions where Trump maintains accounts, meaning banks could receive orders to freeze and transfer funds within 2 weeks. The first critical decision point comes this Friday, February 13th, when Trump must decide whether to seek an emergency stay from the appellate division. That application would need to be filed by 5 p.m. Friday to be heard before the weekend. If Trump misses that deadline, the daily fines continue accumulating through the weekend, reaching $1.5 million by Monday morning. The second critical moment arrives February 16th, 1 week from today, when the first payment becomes due. If Trump pays, it signals acceptance of the penalty structure. If Trump refuses payment, it triggers garnishment proceedings that would become public record. The third inflection point comes approximately 30 days from now, around March 9th, when accumulated fines reach $15 million. According to financial analysts, $15 million represents approximately 4% of Trump's liquid net worth, significant but not yet threatening insolvency. But if defiance continues past that 30-day mark, the financial pressure enters genuinely dangerous territory. Let me lay out the 4 scenarios that are now on the table, and legal experts are genuinely divided on which outcome is most likely. Scenario 1, which I assign 35% probability, is that Trump complies within the next 7 days, produces the documents, and seeks to appeal the contempt ruling as moot while fighting the underlying fraud case. This represents the legally rational path and avoids catastrophic financial exposure. Trump would frame this as strategic compliance rather than surrender. If this happens, the contempt issue disappears, but the fraud case proceeds with prosecutors now holding the documentary evidence they've been seeking. Scenario 2, which I give 40% probability, is that Trump files an emergency appeal seeking to stay the contempt order, loses that appeal within 2 weeks, and then complies under duress while the fine total reaches approximately $3 to $5 million. This scenario allows Trump to demonstrate he fought the ruling while ultimately accepting defeat only after exhausting immediate options. The appeal process buys time for political pressure campaigns, but the financial penalties still accumulate during that period. Scenario 3, which I assess at 20% probability, is extended defiance, where Trump refuses compliance past the 30-day mark, absorbs 15 million or more in fines, and forces garnishment proceedings that result in frozen bank accounts and property seizure threats. This scenario triggers a genuine constitutional confrontation about whether courts can effectively enforce orders against someone who treats judicial authority as optional. It would dominate news cycles and energize Trump's base around persecution narratives, but it also risks financial catastrophe. Scenario 4, the most unlikely but still possible at 5% probability, is that Trump finds a federal judge willing to intervene and override Judge Engoron's state court ruling based on novel constitutional theories. Multiple legal experts describe this as extraordinarily implausible, but Trump's legal team has previously pursued similar long-shot strategies. Here's what you need to understand about the broader significance of what happened today. This contempt ruling tests whether American courts retain practical authority to compel wealthy defendants to follow the same rules that apply to everyone else. For 5 decades, Trump has used litigation delay and financial resources to outlast opponents and frustrate judicial processes. What makes today different is that Judge Engoron has explicitly rejected that playbook, imposing penalties calibrated to Trump's resources rather than accepting the fiction that traditional modest sanctions will influence behavior. If this approach succeeds in forcing compliance, it potentially reshapes discovery enforcement across the civil litigation system. But if Trump successfully defies this order through political pressure, appellate intervention, or simply absorbing the financial penalties as acceptable business costs, it demonstrates that sufficient wealth and political support can indeed place someone beyond effective judicial reach. The next 30 days will determine which of those futures we're heading toward. That's why it's crucial you share this video with everyone you know who cares about whether our legal system can actually function when tested by someone with Trump's resources and determination to resist. Click that share button, get this analysis in front of as many people as possible, and make sure you're subscribed because this situation will develop rapidly over the next weeks, and you'll want real analysis rather than surface-level reporting that misses what's actually at stake here. The question that should keep everyone awake tonight is not whether Trump can afford $500,000 per day. The question is whether our courts can enforce their orders when someone decides the penalties are worth paying to avoid compliance. And that question doesn't have an obvious answer anymore.